Good evening, I'm Camelia and this is KiniNews. Bersih and the CIJ have called for open court proceedings on Najib's pardon bid. This came following the High Court's decision on the proceedings yesterday.
Bersih has urged all court proceedings involving former Prime Minister Najib Abdul Razak's bid to be held under house arrest, to be made public rather than in chamber. Bersih said this in response to the Kuala Lumpur High Court's decision yesterday to allow Najib's application to switch proceedings of his judicial review to be held in the chamber instead of regular court proceedings. In a statement today, Bersih's steering committee said since the case involves a high-profile individual and is of public interest and involves public funds, it needs to be done openly and transparently. It said proceedings of such a high-profile case should be done openly so that the people know its progress. Otherwise, Bersih said it would create a perception of double standards which can erode public confidence in the government and the country's judicial system. Yesterday it was reported that the media was not allowed to cover the proceedings of Najib's judicial review bid after they were switched to the chamber. Najib's lawyer Muhammad Shafee Abdullah told the court that this was due to the nature of the application as it involved sensitive court filing. Meanwhile, the Centre for Independent Journalism said barring the press from covering the case effectively prevents the public from monitoring a corruption that rocked the nation. It said Najib's bid to seek house arrest for the remainder of his jail term is a matter of public interest, and the basic tenets of democracy requires the judicial process to be transparent and not shrouded in secrecy.
Meanwhile, a lawyer from Najib's team has labelled criticism against the decision yesterday as being misplaced. The lawyer said the law mandates all judicial review leave applications to be held in the judges' chambers.
A member of Najib Abdul Razak's legal team has hit out at criticism by several quarters about the former Prime Minister's house arrest court proceedings, which were held in chambers. Speaking to Malaysiakini, Farhan Muhammad Shafee said the criticism of yesterday's proceedings that were allegedly conducted in secret are completely misplaced. He reminded critics that the law mandates that all judicial review leave application, including Najib's bid for house arrest, must be held in the judges' chambers. He cited Order 53, Rule 3(2) of the Rules of Court 2012, which states that an application for judicial review leave must be made ex parte in the judges' chambers. The lawyer explained that to put the issue into context, yesterday's court proceedings were scheduled for leave to commence judicial review and not the substantive hearing on the action's merits. He said the word must suggests that this process is mandatory to be a chamber hearing with the public not invited to sit in. However, he said since COVID-19, chamber matters are often conducted in open court to facilitate social distancing. He said therefore, the request by Najib's counsel for the public to be excluded from the proceedings is 100% in line with the present rules of court. He added that while the reasons cited by the counsel were due to issues of potential sensitivity, which are separate grounds altogether, it does not change the fact that the law requires this stage of the proceedings to be held privately in the chamber.
A professor believes that forcing Bersatu turncoat lawmakers to quit is illegal. According to Sabirin Jaafar, it can be seen as an attempt to interfere in an elected representative's duty.
Bersatu's insistence for the 6 elected representatives who have pledged support for Prime Minister Anwar Ibrahim to step down from their positions is a form of intimidation that can be dealt with the law. This is according to adjunct professor Sabirin Jaafar. He said the statements by several Bersatu leaders, such as its information chief Razali Idris, can be seen as an attempt to interfere in an elected representative's duty as per the penal code. Sabirin added that Razali also committed an offence, either directly or indirectly, by committing an activity that is against the parliamentary democracy. He stressed that he did not intend to wade into political matters, but was merely commenting on the issue from a legal point of view. According to him, those who harass and threaten MPs can be subject to legal action. Sabirin also said that his remark against Razali was not based on the membership invalidity statement alone, but also on the various remarks the latter had lobbed against the 6 lawmakers since last February, including calling them lackeys and not inviting them to the Perikatan National Elected Representatives Convention last month. He said, should there be a police report lodged on the matter, the police can start immediate investigations. He said this in response to Razali asking the 6 Bersatu MPs who backed Anwar to vacate their respective seats without waiting for their letters of sacking. Razali had said that this is because the party membership of the turncoat representatives is no longer valid after the Registrar Societies approved Bersatu's proposed amendments to the party's constitution. The amendment to Article 10 of Bersatu's constitution stipulates that any elected representative who defected from the party would automatically cease to be a member. As such, this would trigger the anti-hopping law per Article 49A of the Federal Constitution, and their seats will be vacated.
The Malaysian Bar wants the AGC and MACC to be held accountable over Zahid's DNAA. It said this during court proceedings in their application to commence a judicial review to overturn Zahid's DNAA.
The Malaysian Bar has contended that the Attorney General's Chambers and MACC must be held accountable over the AG's decision to seek a discharge not amounting to an acquittal, DNAA, in Ahmad Zaid Hamidi's corruption case. Its counsel, Ambiga Srinivasan, said this while presenting oral submissions before the Kuala Lumpur High Court today. The legal profession regulatory body is applying for leave to commence a judicial review to overturn the Deputy Prime Minister's DNAA in the case linked to millions of Yayasan Akal Budi funds in September last year. The former bar president told Civil Courts Judge Amarjit Singh that the judicial review is not academic. She added that if the AG's decision is quashed, the prosecutors would be compelled to continue with the trial. Ambiga said that this is something to rectify the situation. Hence, they invite the court to do so by granting leave for the bar to proceed with the judicial review. According to her, much work has been done for the trial, and this is to be fair to the administration of justice and nothing else. She added that it was critical to the running of the nation to keep all institutions, including the AGC and MACC, accountable.
The government will be drafting a memorandum of understanding on allocations to elected representatives from the opposition. The decision was made following a Unity Government Secretariat Supreme Leadership Council meeting yesterday.
The Unity Government Secretariat Supreme Leadership Council has agreed in principle to consider extending allocations to elected representatives from the opposition. This is according to Deputy Prime Minister Fadilah Yusof. The government chief whip said a draft memorandum of understanding will be prepared and conveyed to the opposition for further discussion. Fadilah added that the council reached an agreement during its meeting in Putrajaya yesterday. In a statement, he said the meeting, which lasted for more than an hour, was chaired by Prime Minister Anwar Ibrahim and attended by top leaders of component parties and the Unity government.
A former technician has been charged again in the Kuala Lumpur Session Court over his alleged comments on the controversial socks with the word Allah. Earlier today, the High Court quashed his sentence after finding that his confession was not clear, unconditional, and inadmissible.
The Kuala Lumpur High Court today quashed the conviction and sentence imposed by a Sessions Court on a technician for posting offensive Facebook comments on the controversial socks with the word Allah. The court passed the verdict after allowing a review filed by Chok Wai Lung. Berita Harian reported that the court ruled that the confession he made before he was sentenced to 6 months in jail and fined 12,000 ringgit was not clear, unconditional, and inadmissible. The decision was made after the judge heard arguments from both the prosecution and defense. The court also ruled that Chok should face fresh charges at a different Sessions Court as soon as possible. Chok had been charged under Section 233, Bracket 1, Bracket A of the Communications and Multimedia Act 1998. He had admitted to making the offensive comments on Facebook and apologized, saying he did not do it on purpose. Previously, he had also apologized after being confronted by an influencer Silat instructor and his friends. His personal details were also circulated across social media.
Join our Muhibah story photo and essay campaign. Share your cross-cultural friendships to celebrate Malaysia's diversity. Submit a photo with friends or family from different ethnic or religious backgrounds, along with a 100-word story to ourstory@malaysiakini.com by April 30th. Selected stories will be featured on Malaysiakini and contributors will receive a free 1-month subscription. Let's build a better Malaysia together. That is all from me today. For more stories, you can go to Kinitv.com. You can also follow us on Instagram, Twitter, YouTube, and Facebook for the latest news updates. If you'd like to support independent media, do consider subscribing to Malaysiakini.com. I'm Kimilia. Thanks for watching.